welcome back to the channel. This is another premiere, not a live stream for those that might get disappointed, but a premiere nonetheless. You can participate live in the chat. But I also have back with us, once again, our friend, Mr. Robertshaw. How are you doing?
Very well, and glad to be back. Yes, work has been intruding quite a lot, so this is a nice little break from that.
I know the feeling. But we're here nonetheless. A few interesting topics to talk about today. First of all, the Alex Jones and his near $1 billion damages payment. I'll bring on screen, actually, a BBC covering of it so people can get just the gist of what we're talking about. So this is what hit the headlines. As you can literally see, 3 hours ago, Alex Jones told to pay $965 million in damages to the Sandy Hook victims' families. For those that may not be familiar with the case, Al, do you want to have a very brief outline of the case?
Yeah, very, very brief outline. You may remember there was a school shooting at a place called Sandy Hook, which was actually in Connecticut, which is going to become relevant in a second. And basically, Alex Jones and InfoWars, the allegation was that they had claimed that it was all a hoax, the parents were all what we call crisis actors, you know, they weren't real parents, that no children had been killed, the FBI were doing a big cover-up, and it was all to attack people's Second Amendment rights. And Alex Jones runs a channel called InfoWars, and they just ran this, and there was a big debate as to whether they'd really run whether they were endorsing the conspiracy theory or merely alerting people to the existence of the conspiracy theory. As it happened, like in this trial, similar to there was a recent trial in Texas, Alex Jones, he got what we call judgment in default because, as we've explained many times before, you have all these discovery obligations in litigation where you have to provide records and things. And Alex Jones was deemed to have not complied with any of the orders. So he wasn't allowed to defend the case on its merits. And they said, right, judgment is entered against you. However, in the same way that actually in defamation cases here, if you get judgment default, there still has to be a hearing about damages. So this was a case where there were 7 parents who were saying, look, you've accused us of basically hoaxing our own children's death, and 1 FBI agent. And the allegation was because of the defamation, they got lots of harassment. The case, I think it's fair to say the trial, again, was a little bit of a circus. In all fairness, Alex Jones had a very, very good lawyer who was really fighting his client's corner, as opposed to the previous Texas, who seemed to be just phoning it in a little bit. This guy really went out there and he ran all the First Amendment stuff. The problem was he was effectively trying to defend the case by the back door on liability, and this was just about quantum. The judge was pretty amazing. She really wore her heart on her sleeve as to what she thought about the case and whether that becomes relevant on appeal. But at one stage where Alex Jones' lawyer just said, oh, just to let you know, it looks like Mr. Jones will be in court tomorrow, she said, right, that's it, I'm calling in sick. And that, that was like in front of everybody.
Yeah, clearly showing what she thought and what she felt at the time.
Yeah. But Alex Jones was effectively, he was not turning up to court. He was live broadcasting, commenting on the court. Every morning they started by showing what InfoWars had shown about the trial, which is all a witch hunt. Here's a picture of the judge, you know, with horns, breathing, you know, on fire, etc. It didn't go down well. And this all ended up in front of the jury. So to be honest, the amount of the award did not surprise people because Connecticut doesn't have a cap on punitive damages. In Texas, they do, and that might be an issue on appeal. Yeah. But also, Connecticut is where Sandy Hook is. It's the heart of it, and the entire community. And again, it was six jurors who had to decide on the damages. Interestingly, in total, the actual plaintiff's lawyer said, "Look, this should be massive. We're looking for $500 million." And he actually came back nearly the full $1 billion. That's spread between 8 different plaintiffs.
Yes, there's this interesting thing, isn't there, about was he just, as you said, alerting people to the possibility of it being a hoax, or there being a hoax, or outright saying that it was? And this is a big thing in defamation, isn't it? Because if you definitively say something, that's one thing, whereas alerting to the question and the possibility, and then as you say, and this is what we call the chase levels, isn't it? So
yeah, and just there's also they have a sort of effectively a equivalent of a public interest defense, because they've got very strong First Amendment rights in the US, and this was one of the things, was like just merely having people on the show, was that endorsing what they were saying? And that never really got tested. because there was no trial on liability. It was all about quantum. So,
yeah, it wasn't actually testing that issue itself, was it? Because it was taken as read, and so yeah. And you just said you feel people were not surprised by it. Let's say, I mean, we'll come on to UK cases and costs in a minute, but is that what you expected, or more than you expected, less than what you expected?
No. I mean, this is, I have no personal experience in Connecticut, but speaking, with Connecticut defamation people, they were saying this is going to really set the record. So we don't have a cap on damages here. Not just the substantive matter, everybody is very upset by Sandy Hook. The fact that they are deeming Alex Jones to not be taking this seriously and effectively just rubbing salt in the wound. They said every day of that trial adds more money. And they will be very aware that InfoWars actually makes money on the back of the broadcasts on these trials. So, there's an argument that in the Texas case, InfoWars probably made more from the coverage of the trial than the actual damages. Because, and also people are just, donating money. So the whole point of punitive damages, which, again, it's not a concept we really have here, but the argument is to punish you. But one thing we do have here is aggravated damages, and that can be used where somebody calculates that it makes financial sense to commit the wrong and pay the damages. Because actually the profit on the back of it, and this does crop up a lot in defamation, where actually, we'll get fined, we'll have to pay 80,000 damages, but we'll sell £200,000 worth of extra copy. And that's something you can bring into account, and because damages here are meant to be compensatory. It's just nebulous there. We think your hurt feelings are worth this amount.
Yeah, it's just putting a monetary figure on it, isn't it? I mean, some things you can quantify. Your car gets smashed up, it's worth a certain amount of money, but if your reputation, then you can show loss of earnings, you can show a monetary figure, but it's a bit like, I had a conversation the other day about holiday claims and things like that. You see the brochure and it shows this fantastic view, and you get there and you're looking at a brick wall in a sewage station or something. It's one of the few where you can get disappointment damages, because the whole point of it was to enjoy it, and if you don't enjoy it, that's the whole point of it.
Well, that's it. They would do that. I've told you, our animal negligence cases, vet negligence cases, where they're treated effectively as consumer contracts, and it's the cost of the repair of the dog or replacing the dog, for instance. But we've always argued, actually, no, if you could recognise disappointment for a holiday or loss of enjoyment because your swimming pool is half an inch shorter than you thought it would be, which is a real case, then surely you should recognise the hurt and the suffering. And that's obviously what happens in defamation. And this happens in sort of personal injury as well. You have general damages and special damages. Special damages are the things you can quantify. I had to get a taxi to the physiotherapist once a week, and this is my taxi bill. Or I had to install a ramp, and this is what the ramp cost. But general damages are you lost the partial use of your leg. We think it's worth X thousand. There's a book called Kemp and Kemp, which effectively lists all the damages awards and what date they were done, and then there's calculators for bringing up to date. So you can sort of go, right, I got 3 cracked ribs, a bruised elbow, and a slight scar. And I used to do a bit of, modelling for Freeman's catalogue. Other catalogues are available. I mean, things like this is one thing that actually happens. When you get facial injuries, they look at effectively how attractive you were before, which seems very, that's like, how do you quantify that without getting into a fight?
Indeed. And a very brief note then, unless there's anything else on this, because there isn't really anything else to say. It's, as you say, it's record setting. And it's justified by all accounts. And then I had another conversation about costs, and people saying, can the costs really be? There were certain people that were talked about, and can the costs really amount to a certain amount? And yes, they can. And this recent Vardy Rooney case in the UK has demonstrated that.
Well, yeah, that's the thing. I mean, costs. In England and Wales, where we have the loser pays winners cost thing, that very much factors into sort of litigation. But one thing that now in big high profile expensive cases, what we call multi-track cases, and this started in defamation, but now it applies to all cases. At a very early stage, you put in a cost budget. Each side says, this is what I think it will cost us to do this case. and you break it down in all the different areas like letter writing, drafting the particulars of claim, conferences, site visits, witness statements. And you have a meeting called a costs and case management conference with the judge. Usually got a High Court master, that's a special type of judge who deals with procedural things. And you will argue about each other's cost budgets, and then you'll get them approved. Now, at the end of the hearing, there is still a determination of costs, but the cost budgets, if you come within 10% of those cost budgets or thereabout, they tend to sort of prima facie go, okay, that's the starting position. But when you have a cost order against you, you normally pay costs on what's called a standard basis, which is you only have to pay for costs that were reasonably and necessarily incurred, and the costs have to be proportional. And it's for the receiving party to prove all that. But you can get things called costs on an indemnity basis, where again, the costs have to be reasonable and proportional, but there's reasonable and necessarily incurred. But there's no proportionality test, and it's for the paying party to argue that the costs aren't reasonable and necessary. So again, that's used to punish people, and that's what. Now, I've been trying to find in Vardy and Rooney whether it's costs on an indemnity basis. I haven't seen the actual court order yet, but the way it's been reported, it sounds like the judge did it on an indemnity basis. He said you can have 90% of your costs, which is a very high figure. You usually look to get 60% of your costs. Yeah. They will, though, go off for what happens is if you get an award of costs, you can say, I want these costs assessed. I want to do a line-by-line analysis of this.
Yeah, because this will be alien to a lot of people overseas, because we have whole hearings and trials and such on the costs themselves. So there's almost like a new trial just to argue about whether it really should have cost that much to have the original trial, because it was a relatively short trial as well. Was it a week trial, I think, wasn't it?
I think it ran about 3 weeks, didn't it? But they weren't sitting every day. So, but 1.5 million.
Well, 7 days, I think it went over, but over 3 weeks or whatever it was. Yeah.
Yeah. I mean, 1.5 million aside, that is within the sort of ball. I mean, that is quite high, but there was a lot of rows about disclosures, a lot of preliminary skirmishing in that case. But it looks like it's been on an indemnity basis. And what will happen there is you say, okay, I want these costs to be assessed. But then you can ask for a payment on account. You say, okay, I don't mind the cost being assessed, some of them, but sure, you're good for the money. I want some of it up front. And you basically pitch the minimum figure likely to recover. Now, what's interesting is you usually sort of say, well, look, let's face it, I'm going to get at least 60. I'm going to probably get 60% of my costs. So pay 60% now up front, and we'll have the rest assessed. And sometimes you'll take a pragmatic view and sort of go, do we really want the assessment? Let's split the difference, something like that. Because these costs. When you go for a cost hearing, again, it's a gamble, because if you apply for, each side makes the offer as to what they think they should pay. And basically, at the end of the day, after the hearing, the side that sort of gets the nearest, it's a very crude analysis of this, the other side pays the cost of the cost hearing. So you might win and say, yes, I got them to pay some of my extra costs, but because I was only 5% out, they said this is a waste of time, you should pay the cost of the assessment. And also, it's the same with fighting them. You might fight them and get them knocked down a bit, but you've only got them knocked down by such a small amount, they're saying you shouldn't have bothered fighting this. Yeah. So again, it's costs on costs.
And there is an emphasis on that. And I've had a number of conversations with the judge in court, we shouldn't be here sort of scenario, because so many cases end up in court just completely unnecessarily. And the one exception in England and Wales is usually family cases, and particularly children cases. There's the standard is no order for costs. But when you get such an outrageous case where it really, really shouldn't have been in court and someone's incurred a lot of costs for it, you may end up with a costs order. Still very rare, but it's not unheard of. But there we are.
You can lodge costs-only proceedings. So say you've had a big row with somebody and managed to settle it without going to court. You can actually say, well, who should pay for all
Yeah, because
you actually just issue a claim saying, dear judge, tell us who should
pay whose costs. Yeah, indeed. Yeah. So there we are. We thought you'd find those interesting. Was there anything else? I think there's one other thing you were going to talk about.
I could do a brief overview of the Colston Appeal. That was topical. I don't know if that's been covered. As people may remember, these are the people who pushed the statute over. They were all acquitted. Now, they ran a variety of defences, and because of the way juries work and just acquit, we don't know on what basis they acquitted. Okay, but the prosecution appealed on a technical ground. Now, the way prosecutions can appeal criminal cases, although in this particular case from a Crown Court, it doesn't overturn the conviction. The acquittal. It just basically says, actually, for future reference, this is the guidance you should give a jury. Yeah. And the issue it was very narrow, actually. It was about the European Convention on Human Rights. Now, just to let you know, in the trial itself, people ran a number of defences. The main one they ran was one called necessity, which is, by doing this, we are preventing a greater crime. So, it's like the classic example, you smash a car window, criminal damage, but it's because of a hot dog in there. Well, you technically committed a crime, but you did it to prevent, a greater crime, or it doesn't even have to be a crime, or it was necessary, or to prevent harm.
Yeah, or you would believe that the reasonable owner would give permission for it. So if it were their dog, their car, they would want you, or even if it wasn't their dog, but it's their car, they would want you to save the dog. That's a reasonable...
Somebody ran consent in Colston as well. Most people ran necessity and said... But the statute itself is, committing an offence. It's offensive. So it's offensive, order or something like that, or it's harassment having to walk past it. But somebody did run and said, actually, I think the owners of the statute would consent, and the owners are the people of Bristol, arguably. The other thing they raised was said, well, we have certain rights in the ECHR. Article 9, 10, and 11 were the points. Article 9 is the freedom to hold a belief. Article 10 is the freedom to express the belief, and Article 11 is the freedom to hang around, with freedom of association, to be with other people. And what the argument is that a prosecution for criminal damage in this particular circumstances was an unjustifiable interference with our Article 9, 10, and 11 rights. And as we've seen from the ACHR, you have certain rights, but they are qualified rights. You can set laws that are necessary in a democratic and free society. And, there's always proportionality again. It's got to be a reasonable, proportional and necessary restriction. So the argument is a prosecution for criminal damage, an unreasonable interference with these rights? And is there an onus on the prosecution to show every prosecution doesn't breach these rights? And put it bluntly, the court said, no, criminal damage, it is a serious offence, and we should have laws against it, and it is preventing criminal damage in the furtherance of ideological aims, even if it's a very honest, true belief and whatever you think about expression. It isn't an unjustifiable interference. You still get the chance to defend yourself in front of a jury, but what they're saying is it is proportionate for the state to try you, and the sort of penalties that are imposed are pretty much proportional. And criminal damage can be a lot of, it doesn't have to be permanent. There's lots of cases saying stuff like chalking, even if it would wash away in the rain, if someone has to come and clean it, that counts as criminal damage. And
it's like the Moore statue, isn't it, that was covered in human waste. I mean, that's not permanent damage, but it's bad enough.
Plug here to illustrate. This is actually something that an artist friend of mine did. And this is a rare, limited edition copy of the actual original, which he put up for auction. And because I'm published at cameras, there you go. So that's fantastic.
Fantastic.
But yeah, I mean, you can see why people found that offensive.
Yes.
That will amount to criminal damage, and the issue would be, would a prosecution be reasonably proportionate? And in light of that most recent appeal, they almost certainly will be, because they have said that. About the only thing that they said didn't amount to criminal damage was like putting clothes on statues. If you put a silly hat on a statue to make a point,
there's no actual damage. But even there was a case, wasn't there, with a sticker, even though then you can take the sticker off, it leaves some residue behind. It's still
that's something that
technically damaged. It's because you've got to do something to get rid of it, is the idea.
Well, that's why they used to prosecute. Remember the old, bill posters will be prosecuted.
Yeah.
Bill posters is innocent. That's because even peeling off stickers, advertising. They used to do it with the cards you get in London phone boxes for certain ladies. It's whether that was criminal damage. They said no, but they can do you for littering.
Yeah.
So, but there you go. Yeah. So that's a little roundup.
Indeed. Bit of a roundup on legal news tidbits, and yeah, very interesting. So the bottom line is, don't do criminal damage, don't defame people, and don't do litigation if you can at all help it.
Yeah, avoid cost hearings.
Yeah, indeed.
Some advice I should be listening myself, because one of the things I'll be doing after this video.
And if you do say anything, qualify it. And there's always, another barrister who I won't name. Caught up with me a couple of weeks ago and said, I do notice how you qualify virtually everything you say. I was like, you've got to qualify these things. Even my tongue-in-cheek analysis of could the TV detector vans of the TV licensing be fraud if they didn't exist? Well, it's technically they could, tongue-in-cheek and all the rest of it. But technically, if it's a false statement with a view to make a gain, it's done dishonestly, that meets the definition of fraud in my book. But as I say, tongue-in-cheek and all very qualified, but there we go. Interesting nonetheless. All right. Well, thank you, Mr. Robertshaw, for your time. I hope everybody, I think you'll found that interesting. Please smash that like button, as always, and subscribe, because we like this channel to grow so we can keep bringing you more updates. With that, I thank you for your time, and we thank you for watching, and ciao for now.